Grace and peace, everybody. You saw the thumbnail, you saw the title. You know that it's National YSL Trial Motion Response Day. Happy day. Man, it's crazy, man. This thing has gone, when I tell you it's gone way over the shark, this thing has jumped the shark, and I'm not even joking. I got something for you today. You all are not ready for it. You're not. You're just not ready for it. Anyway, grace and peace, everybody. We're back, and we are going to look at this YSL, some, dare I say again, some of the responses from the state to the motions that were filed earlier this week. And the reason this is important is because on Tuesday, Judge Whitaker is going to start hearing these motions. So she wants to get all this stuff out of the way, get all the wrangling, all the politicking, all that stuff is getting out of the way so we can get down to some brass tacks on on Tuesday. So definitely this week coming up is going to be firework central. I'm still kind of thinking it's still going to go into a mistrial with prejudice. And that's still my little 2 cents. She went home, she looked online, she started doing some searches. She said, what is this dumpster fire that I've gotten myself into? And they're not real long, though. I will say this. They're not long. And somebody said they're not long because the state really didn't have anything to say. Like, yikes, that's kind of brutal. I think it'll be worth your time. So thank you so much, everybody who's already jumped into the chat. Thank you, everybody who is going to hit that like button and such of that nature. Thank you so much for supporting this channel. My name is Jason. Again, I'm a pre-K law student. And what does that mean, Jason? That means I don't know what I'm talking about. I'm just a guy that lives here in Atlanta, Georgia, that has been very, very interested in these cases that have been going on nationwide, especially locally, and how they impact our society. So I wanted to talk about those. So thank you so much for coming aboard today to hear what I'm saying and from giving social and political commentary from a Christian male perspective. So thank you so much for hanging out with me today. And let's get at it because we got a lot to do. So let's go. Jason, what we got today? Now, one of them that I really don't think we should let slide by is Mr. Doug Weinstein. Now, if you remember on Wednesday or earlier this week when they filed motion, there was the gag order. Like, y'all stop talking to the people and y'all stop going before cameras and y'all stop coming on podcasts. Hey, Doug, holla at your boy. I got you. Okay. That was the idea was like, hey, you all can't, as defense attorneys, be on podcasts, be on blogs, talking to the news about this case. Well, there's a small problem with that. And I think you all know Fani Willis has talked about this case and she's done it quite a bit. I think, in my opinion, the defense has said more, but I don't think it's in volume or scale. It's just the fact that you've talked about it. So Fani Willis has talked about this case. She talked about the election interference case. So I don't think they have as much a leg to stand on. And guess what? Doug Weinstein says about that much. So let's pull Doug in. Doug Weinstein's motion, not actual Doug. But hey, Doug, for real, again, you want to holler at your boy? I'll gladly have you come on. I'd love to meet you and hear what you got to say. Love it. Let's see if I did this right. All right, let us go. All right, so this is Doug's response to the supposed gag order from earlier this week. State of Georgia versus DeMonte Kendrick. Kendrick's opposition to state's motion to restrict extrajudicial statements comes now. Defended DeMonte Kendrick in the above style case in opposition to state's motion to restrict extrajudicial statements, showing the court the following. Everyone is in favor of free speech. Hardly a day passes without it's being extolled. But some people's idea of it is that they are free to say what they like. But if anyone says anything back, that is an outrage. Sir Winston Churchill. I think that was pretty savage. But it's going to get worse. Don't you worry about that. I think if we decide to admit your crimes over a beat, I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it, which you do that for a form of intimidation and to gain and to not be held responsible. This is from the Honorable Fonnie Willis, Fulton County District Attorney, press conference, August 29th, 2022. So what Doug is doing here is pointing out that Fonnie has talked to the news. Why can't I talk to the news? And he's going to show further, and he's going to show more of this as well. Like, look, you get to talk to the press. You get to talk to the public about this case. We get to as well. Free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. The state would apparently like the present, or rather, would like the present trial to be conducted in secret, with proceedings happening in hidden chambers outside of prying eyes of the press or the public. The state repeatedly sought the secreting. Why is it looking like that? Okay. The secreting of which is being streamed today to the public, which I do think is pretty interesting. This is one of the few cases that is not every court in America streams. So there's some states, like New York, you don't get to stream. And I think that's really interesting. I mean, it's good and it's bad. I don't know if we want all cases to be streamed or we want them to not be streamed, or all to be televised and others not to be, or all not to be televised. I don't know, but Georgia's one of those places. And I don't know if it's on the judge or the state or whomever to decide that. So it's just interesting. Just a little caveat. To the extent there are any remarks not specifically in the public record, which statements are generally remarks intended to demonstrate that Kendrick should not be on trial. Justice Kennedy rightly understood the present situation that Kendrick and his co-counsels, or rather his counsel, find themselves in. Kennedy wrote this: an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney may take responsible steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of prosecution deemed unjust or condemned with their improper motives. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be on trial. That's it right there. I mean, I don't know much more. I didn't think there needed to be much more after that, truth be told. I thought Doug crushed it right there. Like, look, this is his job. His job is to make you see his client as just a human, to see his client and to understand that his client should not be tried, should not be in this courtroom at all. Justice Kennedy also correctly notes, I do find it funny when they're writing about somebody that they agree with, they always extol them as doing the right thing. Justice Kennedy rightly notes here. Judge Whitaker correctly discusses here. I just think that's hilarious. All right. Justice Kennedy also rightly notes that the police and prosecution of the government officials and community at large hold innumerable avenues for the dissemination of information adverse to the client, rather the criminal defendant. By contrast, the defendant cannot speak without fear of incriminating himself and prejudicing his defense, and most criminal defendants have insufficient means to retain public relations teams apart from the defense counsel for the sole purpose of countering prosecution statements. Okay. So again, Weinstein is just pointing out here that the only person that can speak on behalf of the client, the only person that can speak on behalf of the accused is defense, is the defense counsel. Finishing this up, Kennedy, he didn't say rightly here, Kennedy cites the important role that defense counsel plays in educating the public on pending cases in writing. Because attorneys participate in the criminal justice system and are trained in its complexities, they hold unique qualifications as a source of information about pending cases. Since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and public rely upon attorneys for information because attorneys are well informed, this may prove the value to the public of speech by members of the bar. If the dangers of their speech arise from a persuasiveness, from their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the sort of dangers that can validate restrictions. The First Amendment does not permit suppression of speech because of its power to command assent. Let's go. Let's finish this up. I love it. Doug is not playing any games with them at all. This is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who is an artist. He writes records. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Kendrick is allowed to take responsible steps to protect his reputation, and those steps may be taken by the council rather than through the public relations firm. Basically, he's saying that, look, I'm his PR guy. I'm speaking on behalf of my client, which I think a zealous advocate is necessary. So I definitely don't see any problem with that at all. But let's finish this up. Let's go. Having smeared Kendrick and his reputation, the state wants to silence him, initially by placing a burden on his free speech rights to write about the world in which he lives and tragedies and injustices around him. And now by holding press conferences denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. So they said, look, you're saying that he can't speak publicly, but you speak publicly. He can't address what you say publicly, but you can continue. Then you can say, you can quash his ability to do so, or my ability as Judge Weinstein, not Judge Weinstein, Doug Weinstein, lawyer Weinstein is saying there. I got you. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Wherefore, Kendrick prays for the court to deny the state's motion respectfully submitted. And that is it. This is going to be crazy. I love it. I think Doug Weinstein did a great job of explaining it. I agree with him. I think he should be able to share what he believes and where he is. If they're able to do it, and Fonnie Willis can say, hey, your rap lyrics are problematic, then I think Doug and the rest of the team should be able to do the same thing and be able to say, like, hey, this is not fair. This is not right. I think that is a very reasonable request. So we'll see.
Yo, hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian.